All right, folks, Steve Palmer here, Lawyer Talk Podcast. You can check us out at lawyertalkpodcast.com. Check us out in the socials. Anywhere you get your content, we are probably there. For those who follow the series, we do different segments. We do a breakdown sometimes. I do Q&A where I ask or answer people's questions that they ask me on the website or in the social media. I do a What's the Appeal? We're going to combine all of that today sort of into one episode because I had a topic that came up in my law practice. And for those who don't know, I'm a criminal defense attorney, been doing it for 30 years. Check me out, palmerlegaldefense.com. But here's what came up. And this is coming up, I think, more and more and more in not only everyday, I'll call it barstool conversations, but also in my legal practice. And that is, the question is this: can the police get access to your social media accounts? And by that, I mean, like, if you've got an Instagram account or a Facebook account or even Google and emails and your cell phone information, how and when can the police get access to that? And this comes up a lot, you might imagine, in my criminal law practice. So say, for instance, the police are investigating a drug dealer and they want to get the drug dealer's cell phone records. I've worked on plenty of murder cases. In fact, I was working on right now an alleged, not alleged, but there was a homicide, and I'm representing somebody who is accused of it. And in the context of the police investigation, they issued warrants and or subpoenas for various cell phone records to try to trace people's location. There's another phenomenon out there called geofencing, where the police will actually get, they'll call Google or call the cell phone providers and figure out what cell phones are actually in the area of a crime, and then work backwards and try to identify potential suspects. So this is a big deal, and it raises a question. We've talked about the Fourth Amendment in other episodes here. And what I love about the Fourth Amendment, what I love about this, about criminal procedure, we call it in law school, but as a very close friend of mine has described it as, it's what they can't do to you, meaning what the police can and can't do. And you might think, well, if I'm a law-abiding citizen, what do I care if the police have access to all this information? I care. I am a law-abiding citizen, but I still care. I think that we have to constantly keep the government in check, not because necessarily of the single case where you've got a police officer investigating a murder, but because generally speaking, power corrupts and absolute power corrupts absolutely. That's why our founders created the Fourth Amendment. They can't just dig through and rummage through our personal stuff and seize it without a search warrant, which is really the question here. Do the police need a search warrant to get access to your cell phone records? Do the police need a search warrant to get access to your Snapchat identity? And I'm going to focus on that one because it's sort of interesting. There is something, believe it or not, there's a federal law that covers it. It's called the Stored Communications Act, 18 U.S.C. Section 2703 C2, which in theory gives the police access to identity type account information if they have what we'll call a subpoena. Now, here's the distinction. If the prosecutor, say a federal prosecutor is engaged in an investigation, they convene a grand jury. A grand jury's a group of folks who sit around and listen to evidence of a prosecutor's investigation. Defendants don't have a right to be there. I don't have a right to be there. It's a secret proceeding. And the grand jury can issue investigative subpoenas, or prosecutors can issue investigative subpoenas, meaning just an order from a court that looks like a subpoena for these companies to produce records. And under the Stored Communications Act, that seems perfectly legit. But we've got another problem. We've got a pesky Fourth Amendment issue. And the Fourth Amendment basically says the government has to have something called a search warrant to gain access to things that we have, or in which we have a reasonable expectation of privacy, meaning we as citizens expect privacy in our homes. We expect privacy to some degree in our cars. We've talked about different fences around our house and can the police have drones? I mean, all these things implicate the Fourth Amendment, and these types of records are no different. And the question becomes, is a subpoena enough, or should the police have to get a search warrant? What's the difference? A search warrant requires a showing of probable cause. What is probable cause? Like everything else in law, it's hard to define, but I know it when I see it. But generally speaking, it's a statement, usually a sworn statement, under oath in front of a judge where a cop actually gives testimony, or an affidavit where the police write out all the reasons they think there is some evidence of criminal activity contained in those records such that we can breach the expectation of privacy with a court order and actually get a search warrant to get to the information. I always tell people when the police are asking for consent to get cell phone records or to get in your phone, you just say, no, I'm not going to consent to that. Go get a search warrant and do it the right way. The police would say, wow, you're making it harder on us. You're darn right we are. Do your job. And the reason we do that is because the police don't always have probable cause, and sometimes they fudge it. Sometimes they try to develop probable cause on something less than enough, we'll say. And when they do that, when I get a case, I can actually file a motion to suppress the information and have it thrown out of court because it was obtained with an invalid search warrant. I have oversimplified this, and these are different topics, but the big picture is a search warrant puts a greater burden on the police to get access to the information than a mere subpoena. And the question is, where is the law going? Well, under the Stored Communications Act, it would seem the police can just send an investigative subpoena and get identity information. So the case I'm working on right now involves Snapchat, and it's a unique social media platform, messaging platform for various reasons. But in this situation, the police simply sent out an investigative subpoena, obtained my client's Snapchat identity, and now are using the information they procured in order to prosecute my client. The question has arisen whether that was good enough. Should the police have instead obtained a search warrant where they had to write out probable cause and not simply send over a subpoena? If they should have obtained a search warrant and they didn't, well, then all the information they received from Snapchat, in theory, gets thrown out of court. They can't use it. If an investigative subpoena is enough, well, they can use it because, it says so, I guess, under the Stored Communications Act. And here's where I think the law is trending. There was a case, the U.S. Supreme Court, rather, has addressed this sort of in the context of cell phone records and cell site location. They call it CSLI, so cell site location information, in a case called Carpenter versus the United States. And for those geeks out there, it's 138 Supreme Court 2206, decided in 2018. And there's a bunch of progeny cases that deal with this. Progeny meaning cases that came afterwards. The U.S. Supreme Court says, no, we have a reasonable expectation of privacy. It requires a search warrant to get access to that information. And a search warrant, of course, has to be based on probable cause. What's different about Snapchat records? Well, one, if you're arguing the police side, they're just asking for identity, not location. Two, Snapchat actually has a disclaimer when you sign up for the service that talks about you're sort of consenting to Snapchat sharing records of if you're engaged in illegal activity as a result of that. So maybe you have a lesser expectation of privacy. The counter argument is, well, wait a minute. First of all, who's gets to decide whether it's illegal activity? If the police just say it, is that good enough? And we are, in theory, consenting for Snapchat to share records, but not for the police to get them. It's different, I suppose. So the question is going to arise: do we have a reasonable expectation of privacy in our Snapchat identities? And again, we're going to be pounding the table, say, well, Snapchat. I don't use it, obviously, but the kids do. I'll snap you or my son, as I say, I got to snap somebody. The idea of Snapchat is, most people know, you send a message and it disappears immediately. So there is sort of this inherent understanding that you're somewhat remaining private just by using the service. So this isn't a very interesting topic that's emerging, and I don't believe the U.S. Supreme Court has actually decided this part of it definitively. The question is going to become, when it comes to Snapchat, when it comes to Signal, when it comes to some of these other sort of messaging apps where people have concealed identities, should the police be able to gain access to the true identity, and what is going to be required for the police to get access to the true identity? We are arguing that requires a search warrant. We're arguing that we have a reasonable expectation of privacy when we use these platforms. If we wanted our identity out there, we wouldn't conceal it with a pen name or a handle or whatever a username. And by creating these alternative names, we are telling the world we don't want everybody to have access to my true identity. Now we can argue. It's an interesting argument to say, well, why shouldn't the government have access to that, and why shouldn't the government be able to see all this nefarious stuff? And again, I sort of go back to my the problem I have. We may trust the current regime, we may trust the current police officer working on it, but can we trust all of them? Because after all, they're all human, and they're all subject to the whims of human frailty, and that means we are all subject to potential corrupt activity. And we can all fudge things here or there because we think what we're doing is right. That's why we have the Fourth Amendment, folks, to protect against that kind of stuff. Even when people don't set out intentionally to violate somebody's privacy or to do something wrong, it happens. Trust me, it happens. I've been doing it 30 years. It happens, and it can happen to you. So I would love to hear your comments on this because, as I said, this is emerging. Shoot me a comment. Shoot me a question. If you've got a scenario you want me to cover here regarding these types of records, I'd be happy to do it. I'm arguing, of course, that the police should have a warrant in order to gain access to anyone's private information. I don't think that's too much to ask given the Fourth Amendment and what it means in this country and the protections that we enjoy here. So check us out. Leave me a comment. Shoot me a question. LawyerTalkPodcast.com. A breakdown, a question, what's the appeal, all wrapped up into one, coming at you week in and week out. Till now.